The following production is presented by League Info Site and the Credit Union Broadcast Experience, QTV.
Thank you for joining me at the CU Compliance Connection by InfoSite on Cube TV. I'm Sean Wolbert. This presentation will continue our focus on the new mortgage lending rules released by the Consumer Financial Protection Bureau with an in-depth review of two important sections of the Loan Originator Compensation Requirement that amends the Truth in Lending Act, or Regulation Z. Our discussion today will assess the new regulatory requirements for arbitration agreements and the prohibition against single premium credit insurance. These changes go into effect on June 1st this year, so it's important to understand the new rules so the credit union can begin to implement changes to ensure it is in compliance by the time the rules are in effect. When the Dodd-Frank Wall Street Reform and Consumer Protection Act was passed by Congress, the focus was to protect the rights of consumers. As a part of this protection, Congress did not feel it was appropriate that a consumer would be contractually prohibited from seeking court assistance in matters pertaining to their home. In the past, the federal government has expressed a policy of support for arbitration clauses because they reduce the burden on courts to resolve disputes. The Federal Arbitration Act permits compulsory and binding arbitration and allows creditors to require arbitration, which results in both the member and the credit union giving up the right to appeal an arbitrator's decision to a court. However, due to the Dodd-Frank Act, mandatory arbitration agreements cannot be required or included on mortgage documents in the future. Section 1026.36H of the Loan Originator Compensation Requirements contains the prohibition on mandatory arbitration clauses and waivers of certain consumer rights pertaining to a member's primary residence. An arbitration clause is commonly used in mortgage documents and requires members to resolve their disputes through an arbitration process rather than filing a lawsuit against the credit union. The scope of the requirement reaches beyond the act of the arbitration and includes other non-judicial procedures as a method for resolving disputes between the member and the credit union. An example of the non-judicial procedure would include requirements for mediation. It is important to note that the new Consumer Financial Protection Bureau rules for loan originator compensation requirements for mandatory arbitration only pertain to clauses that relate to the member's primary residence. This is not applied to other types of loans at your credit union. Generally, arbitration clauses contain a statement that in the event a dispute arises between the credit union and the member, both parties agree that the dispute shall be referred to an arbitrator or a mediator. And arbitration will commence in accordance with the applicable United States arbitration and mediation rules of arbitration. The arbitrator's decision shall be final and legally binding. The clause will also contain guidance on what will occur if arbitration fails, and often states that each party will be responsible for its share of the arbitration fees in accordance with the applicable rules of arbitration. In the event a party fails to proceed with arbitration, unsuccessfully challenges the arbitrator's award, or fails to comply with the arbitrator's award, the other party is entitled to costs to pursue the matter, including reasonable attorney's fees for having to compel arbitration or defend and enforce the award. If a dispute over a member's loan on their primary residence does arise, the member and the credit union can agree to use arbitration or another non-judicial procedure, like mediation, to come to an agreement, but this process cannot be mandated and required through the member's contractual agreement with the credit union. In the coming months, credit unions will want to review their home equity and mortgage documents to determine if they contain a mandatory arbitration clause and remove the clauses prior to June 1st, 2013. Another provision of the new Loan Originator Compensation rules is a prohibition on the financing of single premium credit insurance products. Revised Section 1026.36I of the Truth in Lending Act generally prohibits a credit union from financing any premiums or fees for credit insurance in connection with a closed-end consumer credit transaction, secured by the member's principal residence. This includes both closed-end and open-end loans. The prohibition applies to credit life, credit disability, credit unemployment, credit property insurance, or any other accident, loss of income, life, or health insurance protections, and also includes any payments, directly or indirectly, for debt cancellation or suspension agreements and contracts. The same provision in the rule also states that the prohibition does not apply to credit insurance for which premiums or fees are calculated and paid in full on a monthly basis, or to credit unemployment insurance for which the premiums are reasonable, the creditor receives no compensation, and the premiums are paid based on a separate insurance contract that is not paid to the credit union or an affiliate of the credit union. Basically, this means that credit insurance is allowed in 3 circumstances. First, where the single premium credit insurance is paid separately from the loan and is not financed as a part of the loan. Second, where the insurance is paid in full each month. And third, there is a limited exception for credit unemployment insurance when premiums are reasonable and the credit union does not receive direct or indirect compensation in connection with the insurance premiums. The credit insurance programs that have been targeted by this portion of the rule were created to assist members whose lives are affected by a tragedy and need protection so that they do not lose their homes. It will be important for credit unions that provide these products to contact their third-party credit life, disability, and other insurance providers to determine how they can continue to offer these credit insurance products to the members while complying with the prohibitions and the requirements of the new regulation. Additional information on these rules can be found on the Consumer Financial Protection Bureau's website at cfpb.gov. Please stay tuned to the Compliance Connection for further detailed reviews of the new requirements from the Dodd-Frank Act and the CFPB. Thank you for joining me. I'm Shawn Wolbert with the CU Compliance Connection by InfoSight, only on Cube TV.
Thanks for watching the #1 compliance program for the credit union community. Stay tuned.